All right, everyone, we are live on YouTube. I'm going to ask that everyone please make sure that we keep today a Friday. Let's not try to turn a Friday into a Monday. Sorry about the late start, but we are having problems with our internet connections here at the courthouse. And for some reason, all of the jury rooms were locked. The deputies couldn't get into the jury rooms this morning, but hey, it's going to be a great day and we're going to keep it that way. All right, so these are the rules for the 187 District Court. Whatever you cannot do if you were physically in the courtroom, you cannot do at your home or on this Zoom screen. So what that means is there's to be no smoking, no cooking meals, no driving and Zooming. I refuse to be a witness to an accident. If you can't text and Zoom, if you can't text and drive, you definitely can't Zoom and drive. So let's not do that. Let's not cause any accidents. To everyone who's on the Zoom screen, to the defendants, and to any inmates, you're not allowed to use the chat box. If you use the chat box, your case will be reset and you will be required to appear in court. So anyone who does not want to have to appear in court, then you need to behave professionally on Zoom. To all of the attorneys, just one moment. I'm dealing with this small screen and this small screen is causing problems. To all of the attorneys, if you have a plea bargain agreement, you need to put that in the chat box and you will put that in the chat box to Norma Ferguson. She is our court coordinator and she's listed as N. Ferguson on the Zoom. Just one moment. And bear with me because I am not using the desktop. So it is hard for me to see on this small screen. All right, attorneys, I'm going to call your name. That's the order in which you will appear. If you need to go to another court and Zoom to another court, you're more than welcome to Zoom to another court. However, if you leave to go to another court and your name is not called, and your name is called, you will be bumped and someone else will take your place and you'll be put at the end of the line. Also, do not contact the coordinator asking for her to excuse you because I'm the only person who can excuse you. And everyone, if you will give me a minute because this screen is just entirely too small for me. I'm going to see if I can have the desktop work. Just give me a moment, please.
Norma, I sent you a chat about my client, please.
All right, everyone, I have moved to the courtroom. So hopefully things will work properly from here. All right, so this is the order in which attorneys will appear. Greg Damaris, Eduardo Jimenez, James Toshi, Joe Bohack, Daniel De La Garza, Jesse Sanchez, Judy Wimmert, Kurt Kinnear, Martin Guerra, Nathaniel Navy, Raphael Leal, Robert Porter, Rodolfo Cepeda, Tony Hernandez, Robert Maurer, and Michael Goins. Is there any defense attorney that I have missed?
Your Honor, I didn't hear my name, Linda Corley. I might have missed it, but.
All right, let me make that happen. Linda Corley, anyone else?
And Judge, I would just say you called my client's name, Kurt Kinnear.
Ah, thank you. All right. Thank you. The person who's listed as Art A, could you unmute for me, please?
Yes, ma'am.
All right, why are you laying in bed?
I'm sorry.
All right, you need to appear in court. I've already made the announcements that whatever you cannot do if you're physically in the courtroom, you can't do on Zoom.
Okay.
And last I checked, there are no beds in the 187 District Court. And if a bed were in the 187 District Court, it will be here as an exhibit. And if it were as an exhibit, you wouldn't be able to lay on it at that time unless someone requested that you do that as a witness. So I'll see you in the 187 District Court. It's on the 4th floor, 300 De La Rosa.
Thank you.
You're welcome. All right, to everyone, I'm going to open up the breakout rooms. When I open up the breakout rooms, it will invite you to a breakout room. Please do not go to a breakout room unless I specifically assign you to a breakout room. And to attorneys, when I call your name, I will need the name of your client and whether or not they are criminal trial division or family violence. The prosecutors have the ability to move throughout the breakout rooms. So please do not leave a breakout room until a prosecutor sees you and visits you. If you leave the room, it will show that that room is empty and the prosecutors will skip over you and skip over your case. And everyone, I appreciate your patience. For some reason, all of the systems were down on a particular side of the courthouse today. The deputies could not get in the jury room. My desktop is not working as it should. So hopefully someone will come to fix that soon. I'm not a computer expert, nor do I pretend to be one. All right, Greg DeMaria, you're up first.
Good morning, Your Honor. How are you doing, Judge?
Great. How's everything going with you?
Going well, going well. So I have Joseph Valadez. He should be in attendance. And if I was conferring with Marcus on this case, if he is available, or anybody else in the CTD.
All right, I'll send you to breakout room number 2.
Thank you, Judge.
You're welcome. Eduardo Jimenez.
Yes, Judge. I'm here for Janelia's crew and its criminal trial division. I would need to consult with an ADA, please.
I'll send you to breakout room number 3.
Thank you, Your Honor.
You're welcome. James Toshi.
Judge, good morning. I am here in an off-docket capacity. You had asked Norma to place us on a docket regarding a no contact order on a prison case. Do you recall our discussion of this?
What is the defendant's name? And that will perhaps jog my memory.
Roland Luna is his name.
Yes, I do remember it.
The complainant is actually in a waiting room. I don't know if you want to hear from her or not, but if you're inclined to lift the no contact, then I will fashion an order for you. But you
All
would
right, yes. I'll need to hear from her, but it doesn't show that she's in a waiting room.
Christina Martinez is her name, and I think she is, but I can't tell.
Is there Christina Martinez on the Zoom? Yes, she's on the Zoom. Just give me a one moment, Mr. Toshi.
Yes, Judge. Thank you.
You're welcome. Joe Bohack. You're muted.
There we go. I got an MTR on Goggins and I'm looking her up. I thought this was from a drug case, so it should be criminal trial division.
All right, what is the first name?
Raisha. Unless I've looked, oh shoot, let me see, hold on. Yes, Raisha Goggins. I think I looked at the wrong case though.
All right, just one moment.
Let's see. Yes, from a drug case on another MTR.
All right, I'll send you to breakout room number 4. Daniel De La Garza. All right, we'll come back to him. Jesse Sanchez.
Yes, Judge, good morning. I'm here on Adam Ayala, the criminal division. It's an MTR. I can consult with the DA.
I'll send you to breakout room number 5.
Thank you, Judge.
You're welcome. Judy Wimmer.
Morning, Judge. This is a recall from yesterday. Alexander Streeter, we have our plea paperwork ready.
All right, is there a prosecutor available to take this plea?
Yes, this is CTD.
I can take the plea, Judge.
All right, thank you. And everyone, if you're not a part of this hearing, if you could please mute, please. And Ms. Wimmer, you need to show your video.
Gotcha.
And Mr. Streeter, you need to show your video. Court is calling 2020 CR 1544, State of Texas versus Alexander Streeter. Can I have the parties announced for the record for the state?
Hunter Morris for the state.
Judith Wemmert for the defendant.
And are you Mr. Streeter?
Yes.
All right, everyone, just one moment. Thank you. We're proceeding by video because of the pandemic. Any objections from the state or the defense?
None from the state.
Ms. Wemmert, you're muted.
No, ma'am.
And Ms. Wemmert, when you're not speaking, if you could please mute yourself because I'm getting feedback from your end. Mr. Streeter, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
I did.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
I did.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, ma'am, I did.
Court will find that the state is in compliance with discovery. Mr. Streeter, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
Yes, ma'am, we do.
State, it appears that you're proceeding on both counts in the indictment. Is that correct?
That is correct, Judge.
Mr. Streeter, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
I did.
Did you understand in count 1 and in count 2, you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, ma'am, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do.
Mr. Streeter, has anyone threatened you or coerced you or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you have a chance to review the plea bargaining page with your attorney and did you understand it? Just 1 second, your attorney has fallen off the screen. To the court reporter, we'll just take a short break on this hearing and wait for the attorney to zoom back in. Martin Guerra, who do you have?
Good morning, Your Honor. I have Edward Guitron. That's a family violence case. I had conferred last week with David Martin, and we actually have a plea agreement. We're scheduled for a plea today, and all the paperwork has been submitted.
All right, if you will, I'm going to send you to a breakout room with your attorney. I'm sorry, with your client. And the court clerks will meet you there to make sure that your client has everything.
Okay.
So I'm going to send you to breakout room number 1. And Mr. Guitron, if you'll go to 1. And Martin Guerra, if you will go to 1. And to the clerk, if you all will go to 1, please.
Thank you, Judge.
You're welcome.
May we be excused after conferring with the probation department?
Who is this speaking?
Ms. Wemmert?
You're not finished with your plea.
Oh, okay.
You left the screen. Your system went down.
Yes, it did.
Mr. Streeter, could you unmute yourself, please? And we're back on the record.
Yes.
Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is proceeding on counts 1 and 2. There's a $1,000 fine. State recommends deferred adjudication. And there's restitution to Dylan Klaus, DYLAN KLAUS. Did you understand that to be the plea bargain agreement?
Yes.
State, is that the plea bargain agreement?
It is, Judge.
Defense, is that the plea bargain agreement?
Yes, ma'am, it is.
Mr. Streeter, did you review the paragraph entitled Waiver of Appeal with your attorney? Did you understand it, and did you electronically sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, ma'am.
Also, outside the plea bargain agreement, Mr. Streeter, did you understand that the state is requesting that your deferred adjudication be for a term of 6 years? There be a TAP evaluation, 200 hours of community service restitution, no contact with Dylan Klaus, and no harmful or injurious contact with Madeline Streeter, and a MIC evaluation. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes.
Then to count 1 in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
Count 2 of the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, do you have any evidence to support the defendant's no contest, please?
State offer states 1 with attachments, Judge.
Any objection?
No, ma'am.
Mr. Streeter, did you review a document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes.
And did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty of count 1 and count 2. However, the court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am, please.
Is there anything you wish to say on behalf of your client? Is there anything you wish to say on behalf of your client?
No, Judge, we would just ask that the court respectfully follow the plea bargain.
Mr. Streeter, what drugs were you using that night?
LSD.
How often have you used LSD?
At the time of the incident, I used LSD over a period of a year to a year and a half. and with a frequency of approximately once a month
But why were you using LSD?
as a recreational substance.
Where do you work?
I work at the Patriot Heights Independent Living and Healthcare Center that is currently owned by Ensign Company.
Doing what?
It is a residential and medical facility for elderly individuals. I work there as security. So my responsibilities include keeping track of who enters the property, as well as monitoring our safety pendant devices for the independent living residents and responding
And do
to
they
those.
know that you have been using LSD and you have an aggravated assault with a deadly weapon charge?
Not to my knowledge.
All right, because I'm not gonna, here's the thing, with what I'm reading, you're not gonna be allowed to work as a home health care provider, as supervising vulnerable people. And vulnerable people to the court are people who are elderly and people who are minors. So I'm not gonna allow that to continue. And I don't think it's appropriate for you to be security anywhere when you have 2 counts of aggravated assault with a deadly weapon, regardless of whether it was because you were in the throes of some sort of LSD hallucination. How old are you?
I'm 24, Your Honor.
All right, so you're at an age where you should know better. I don't know what's up with young people that act as though they don't know that LSD, heroin, meth is not something that you should be starting. And I do believe that once the company you are working for becomes aware that you have this criminal case, I don't think they would allow you to continue to work there because you're a liability. You understand?
Yes, Your Honor.
So you're going to find a new job, because whether they want you to work there or not, I'm not going to allow you to work there because there are vulnerable people there.
Yes, Your Honor. I
So
understand.
where are you living?
I live currently at 74 Knights Peak.
Well, not the address. When I say where are you living, I'm sorry, that's my fault. Who are you living with? Or are you living by yourself?
At the moment, I'm living by myself, but I do anticipate that within the next couple of months, my grandmother will be moving into this place that I'm living as well. But currently I live alone.
Okay, and whose idea is it for, is your grandmother going to live with you?
Yes,
Whose idea is that?
that was hers.
All right, I have no control over who wants to live with people, but I personally don't think that's appropriate, because I don't think you're at the stage in your life where you should be living with anyone, because this all happened under the roof of someone else with you and one of the complainants. So his sister, who's listed in the indictment, it says that there's to be no harm or injurious contact with her. Has anyone talked to the complainants in this case? Does she want to have contact with him?
This is Marcus Sanders for the state. We've tried multiple times to get in contact with the sister and we weren't able to. Same with the non-related victim. I believe Ms. Weimer spoke to him though, but he never returned our phone calls.
Okay, thank you. And Mr. Streeter, if you're tested today, what are the results going to be?
Absolutely negative.
All right, this is what the court will do. 6 years deferred adjudication. There's a $1,000 fine that'll be probated. Restitution, if any, to Dylan Kloss. 200 hours of community service restitution, and no payment of the hours will be accepted by the court. You must do those 200 hours. No contact with Dylan Kloss. No harmful or injurious contact with Madeline Streeter. Proof of employment. within 30 days. No employment with vulnerable persons. And that means no employment with the elderly or minors or as a home health care provider. And what's the name of the employment where you work now again?
The facility name is Patriot Heights. It is
No
owned by,
employment with Patriot Heights. Random field visits 3 times per month. UA hotline or patch. I personally don't think you need the MIC evaluation. I think that you were using LSD and you had a hallucination from the LSD. State, your thoughts on the MIC evaluation?
Marcus Sanders again for the state. You're asking why did we ask for
No,
a
I
MIC?
mean, do you think there's a need for a mental health evaluation? I think he was just high on LSD and he had hallucinations. That's what I'm reading in the police report. Does he have any prior mental health diagnosis? Does anyone know? Defense, Mr. Streeter?
No, Judge, he does not. And I would represent to the court that several days after this incident, he did voluntarily seek a mental health evaluation. And the results of that evaluation were that at that time, no further mental health therapy was recommended. That has been the status since the incident.
All right, Mr. Streeter, do you need any mental health intervention by probation?
no, Your Honor.
All right, probation, is there anything else that Mr. Streeter needs?
No, ma'am.
All right, Mr. Streeter, do you need anything else from the court in order to be successful on this deferred adjudication?
No, Your Honor.
All right, and Mr. Streeter, when I say that there's to be no employment as a home health care provider, I know that sometimes what ends up happening is people have elderly relatives and they end up being their home health care provider, and the government, i.e. taxpayers, end up paying for that. You are not allowed to do that either. Do you understand?
I understand.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes.
And before we go off the record, state what's your intention that counts 1 and counts 2 were the run concurrently?
Yes,
So
Judge.
just with Marcus's negotiations, but that was my understanding.
All right, and I will put count 1 and count 1 are concurrent. All right, we can go off the record. Mr. Streeter, from here on out, while you're on deferred adjudication in this court, every decision that you make, the first thing you need to ask yourself is whether or not this decision will result in me possibly going to prison for 20 years. You understand?
Yes.
All right, good luck to you, Mr. Streeter. I'm going to send you to a breakout room. Probation will go over conditions with you. And I will send you to breakout room number 1.
Thank you.
All right, and then after she goes over conditions, you are excused.
Thank you.
Thank you, Judge.
You're welcome. All right, everyone, just give me a moment. Nathaniel Navy.
Yes, Your Honor. I have Kurt Kinnear. It's a criminal trial.
All right, I'll send you to breakout room number 6. Raphael Leal.
Yes, Your Honor.
Raphael Leal.
Yes, Your Honor.
Yes, who do you have?
Victor Manuel Vela,
Criminal Trial Division or Family Violence?
family violence.
Rebecca, were you able to go to one?
Yes, but there's attorney and Gutran in there waiting with the clerk. So do you want us to go to a different? You want to move
Yes,
us to
I'll
a
send you to
different?
breakout room number 2.
Okay, thank you. And are you going to move the other ones into
Yes.
2? Okay, thank you.
All right, Raphael Leal, I'm going to send you to breakout room number 6. Robert Porter.
Good morning, Your Honor.
Just 1 second, Robert, I'm sorry. All right, Robert Porter, who do you have?
I had Lamont Curry, Your Honor. Having issues in contacting him.
All right, he's not in the courtroom and he's not on the Zoom screen. We're going to take that up. All right, to the clerks in the back, could I have a file on Lamont Curry, please? All right, we'll get right back with you, Mr. Porter. Just give us a moment while the clerks pull that file for me.
Thanks, Judge.
Mr. Zepeda?
Good morning, Your Honor. I'm here on Adonis Romero. He was the one that was in court yesterday that was taken into custody on a, well,
He's recalled for Monday.
well, they sent me the Zoom for today.
Okay, I'm sorry. It's recalled for Monday because you told me that his case in the other court would be taken care of by Monday.
Yeah, I'm supposed to talk to Judge Longoria on Monday.
Okay, all right, we'll see you on Monday. Sorry about that.
That's all right. May I be excused then?
Yes, thank you so much for coming in. Happy
Thank you.
Friday.
You too.
Okay. Tony Hernandez.
Good morning, Judge. We conferred earlier. We've got an offer, and I need to consult with his immigration lawyer. We were just hired on this case about a month ago after, so we'll pass.
Who's your client?
I'm sorry, Herrera Mejia is his name, Jonathan Herrera Mejia.
All right. All right, Norma.
Yes, ma'am.
On Herrera Mejia.
Yes, ma'am.
Can you give this a 30-day reset? This is an old case, Mr. Hernandez. So when we come back, whatever needs to be done with immigration needs to be done.
June 1st.
So we will see you back on June 1st.
Judge, that's this is May. Can we have the second week of June, Judge? So we have 30 days. Because his immigration lawyer is in Florida.
Ah, okay.
Yeah,
Norma,
so
can
he's
you give me a
challenged to
date
get
the
over.
second week of June? Thank you.
June 10th.
June 10th. Thank you, Judge. Thank you, Norma. Thank you, Judge. I appreciate that.
All right, thank you. You're excused. All right, and can I have a prosecutor on Mr. Lamont Curry, please? He's not here.
Hunter Morris.
All right, the court is calling 2020 CR 5704A, State of Texas versus Lamont J. Curry. Could I have parties announced for the record, please, for the state?
Hunter Morris for the state.
For the
Robert Porter.
defense?
Robert Porter for Mr. Curry.
All right, we're proceeding by Zoom because of the pandemic. Any objections from the state?
None from the state, Judge.
Any objections from the defense?
None from the fence.
This hearing was scheduled yesterday. The court waited until 3:10 p.m. for the defendant to appear on May 6th. As stated, the hearing was scheduled on May 6th at 9 a.m. The court gave defense an opportunity to get in contact with their client today. This hearing was scheduled at 9 a.m. It is now 10:06 a.m. Deputy Laura, has there been a Lamont Curry in the courtroom at all today?
No, Your Honor, he has not.
Defense, have you had any contact with your client?
I have had contact with the girlfriend. She has reached out to him. It's my understanding he was having Wi-Fi issues. And again, we're trying to get him to my office to proceed with the Zoom.
State, I will note for the record that the bondsman filed an affidavit to surrender surety. The bondsman in his affidavit to surrender surety stated that they had sent a message to Mr. Robert Anthony Porter at his office and left a message at the attorney's phone number. The court then signed the affidavit to surrender surety. And so the court will remand your client without bond. If you are able to get in touch with your client, let the court know, and the court will, of course, reconsider.
Thank you, Judge. Judge,
Yes.
when did that bond company state that they notified me?
They're stating that they notified you yesterday.
Is that a sworn affidavit?
Yes, it's a sworn, I'm sorry, yes. And no, not yesterday. I'm sorry. This affidavit is sworn to on March 18th, 2021.
Oh, it's March 18th. Okay.
Yes. And they left it at your 210391 number. That's what they say in their affidavit.
We'll definitely check into that.
All right. If that didn't happen, let the court know. I take everyone's affidavits as they're swearing to it. I take it as true unless there's something else. All right, if there's nothing else, Mr. Porter, you're excused.
Thank you, Judge.
Hey, Judge.
Robert Maurer.
Judge, I've got an MTR of Vincent Garza. I've already got an agreement. I just need to go to a breakout room and have him sign the paperwork. We'll be good to go.
Okay.
He's in jail.
All right, I'll send you to breakout room. Let me see which one I have open. I'll send you to breakout room number 8.
Thank you.
Mr. Garza, if you'll go to 8.
Yes, ma'am.
And Mr. Maurer, if you will go to number 8.
Yes, ma'am.
There you are.
Your Honor, if you have a moment, may I speak to my client, Janelius Crew?
Just one moment. You are in breakout room number 3. If you'll go back to 3. Is your client in custody or on bond?
In custody, Your Honor.
All right, he hasn't appeared on screen just yet. Just give me a moment. Norma, can you check on Mr. Crew, please?
They're bringing him out in a few minutes, Judge. He's not out yet.
All right. Michael Goins, who do you have?
Your Honor, I have Leroy Torres.
And is it family violence or criminal trial division?
Your Honor, I've already talked to Criminal Trial Division. This is the one where it's a evading of arrest and a DWI. We've been trying to get this pled in court for. They were going to dismiss the felony evading arrest, but we've been unable to do that to this point.
So what is the issue? Is it that County Court 4? Or are you saying they're not?
I think it just got messed up in the last week with their current caseload, Your Honor. We have an offer. The offer's been accepted. We thought we were going to go yesterday. We never received a Zoom link. or the paperwork.
All right, who's the judge in county
I
court?
sent emails off.
All right, who's the judge in county court number 4?
Judge Jimenez, Your Honor.
All right, just one moment. Let me see if we can get that done today. Everyone just give me a brief moment, please.
Miss Goggins, can you go to breakout room 9?
Mr. Goins, what's your client's name? Leroy Torres?
Leroy Torres Jr., Your Honor.
What is the cause number?
One moment, Your Honor.
And I need the county court 4 cause number.
Yes, ma'am. Your Honor, the County Court of Fort Lauderdale cause number is 654118.
Thank you. All right, Mr. Goins, I spoke with the judge in County Court 4. They are actually Zooming right now, so you should be receiving a link shortly.
Okay, thank you, Your Honor. May Leroy and I be excused so we can go to that court?
Yes, but just wait here for a moment because I want to make sure that everything goes smoothly.
I understand, Judge.
All right, thank you.
I'll let
All right,
you know
Linda.
when I get to Zoom.
All right, Linda Corley.
Good morning, Judge. I have Vermont Bowie and it's CTD. I have been conferring with Marcus. I should have a plea deal very close. We just need to get some videos and review those videos. So if the court would allow me to have a 30-day reset, Marcus is checking on those already. He's made a phone call this morning on those.
All right, just one moment.
I guess that's what I would recommend.
All right, Marcus Sanders, are you there?
Judge,
Yes, when do you think these videos will be ready?
I think within a couple weeks. I think Linda needed a little more time to make sure she can get her client in to watch them and everything.
All right, and is it Lamont or Ramont?
Ramont with an R, like Robert.
Okay. Norma, on Ramont Bowie, can we have a 3-week reset, please?
Yes, ma'am. And it's going to be for Judge, just a reset?
They're saying a plea.
Judge, if I could request 4 weeks. I mean, once we get the videos, I've got to watch them all and isolate the sections for my client. I don't know if it's 1 video or 15. If I could just get a 30-day reset, I would greatly appreciate it.
All right, Norma, give them a 30-day reset.
You can come back on June 2nd.
I'm sorry, when, Norma?
June 2nd?
All right, we'll see you back on June 2nd. After that, there'll be no further resets. The court normally does not have a pre-hearing docket.
Okay, thank you, Judge. I appreciate it. May my client not be excused?
Yes, you're both excused.
Thank you.
Judge, I'm back.
And Robert Maurer, I'm seeing if I have your paperwork.
Okay.
And Mr. Toshi,
Yes, Judge.
I think I see your witness in the breakout room.
She was in the main room. No, I see her in the main room, Judge. She's iPhone Christina is what her screen name says.
All right, iPhone, Christina, could you unmute, please?
Yes, ma'am.
All right, I'm not going to place you under oath just yet, but your attorney is telling me that you wish to have contact with the defendant.
Yes, ma'am.
All right, why do you want to have contact with him?
Well, he's been my boyfriend for almost 2 years, and we've never had issues like this before. And I know that he is schizophrenic and he has mental problems, and he was not on his medication at the time that all of this happened. And I honestly don't think that it was meant to happen like this.
All right, could someone from either criminal trial division or family violence pull up the criminal history on Roland Luna? Mr. Toshi, do you have a SID number?
I do, Judge, and I'm looking at his history now. His SID is 915236.
I have it pulled up, Judge.
Yes, what is his history?
Got a notable amount of arrests, sentenced for assault choking, incident date of December 2020.
Does he have any other assaultive behavior other than the assault against Miss Martinez?
There was an arrest, I guess that's related to the sentence case. I do not see a separate incident other than the December 29th, 2020, although it does appear that he is a habitual.
All right, and what was the cause number for this case, please? The assault choking?
Excuse me.
The assault choking is 2021 CR 1612W.
All right, we're going to go on the record, Mr. Toshi, so that Miss Martinez can tell me what she's requesting and what she wants.
Sure.
And I'm not necessarily need a prosecutor for this. The defendant has already been sentenced, but the court ordered a no contact order with Miss Martinez, and she's here telling me she wants to have contact with the defendant while he's in prison. Court is calling 2021 CR 1612W, State of Texas versus Roland Luna. Could I have defense announced for the record?
James Tochi for Mr. Luna, Judge.
All right, and the state is remaining silent on this. The state has informed the court actually off docket that he has been sentenced. So they really don't want to give input as far as the no contact order. And with the no contact order, the state left that up to the court as well during sentencing. So Mr. Toshi, is there any witness you would like to call?
Yes, Judge, I'll call Miss Martinez here, but just to give you a very, very brief Cliff's Notes, she's been in contact with the warden of the facility that Mr. Luna is in, and they recommended this course of action that we're undertaking today. What the warden of the facility had indicated is, if the judge will just give us something in writing via email, it can be a motion or that indicates the no contact order has been lifted by the judge, they will allow them to communicate via email and phone call. They're currently trying to figure out how to get married while he is in custody. And this is kind of personal, but they were, trying to have a child, and that did not work out. And this was all while the case was pending. So just to give you some backdrop. But I will call Ms. Martinez right now, Judge, if you would like to swear her in, Christina Martinez.
Ms. Martinez, if you can raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, please, and could you state your name for the record?
Christina Martinez.
Defense?
Thank you. Ms. Martinez, let's just kind of cut right to the issue. Why are we here? What are you here asking Judge Boyd to do today?
If we could lift the no contact order, so that way I could have contact with Roland. I am the only person that he has. And like you said, we are trying to get married.
Okay. Are you fearful of Roland in any way?
Not at all.
Okay. And have you been in contact with the facility that he is in, and have you talked to the warden?
Yes, I did. I talked to the warden in Huntsville, and they told me that if I could get paperwork saying that the no contact was lifted, that we would be able to have contact. But the paperwork would have to go to them.
Okay, and that's why we're here today. You're asking the judge just to order that the no contact order be lifted.
Yes.
Okay. Are you also currently trying to get married to Roland Luna while he is in custody?
Yes, sir.
Okay. And is that the intent, whether it's in custody or if he's paroled, is the intention the two of you are going to get married?
Yes, sir.
All right. That really is all the questions I have, Judge. It's a very kind of simple request. If you wish to inquire, feel free.
All right, Ms. Martinez.
Yes, ma'am.
The incident that occurred with the assault choking, the reason the defendant is in the prison, has that ever happened before?
No. No,
Has
ma'am.
he ever been violent with you beyond that incident?
No, ma'am.
And why do you think that incident occurred?
He wasn't on his medications and he needed to be on them. We went to the hospital and he didn't want to stay because he was afraid that he was going to be alone by himself in the hospital. And when this happened, I think 2 or 3 days right before, we went to the hospital 2 or 3 days right before all of this stuff happened, because he felt like he was going to harm himself. He felt suicidal.
Stacey, is there somebody here for me? Okay.
All right. I don't have any other questions with Ms. Martinez. Anything else from the defense?
No, ma'am. Not at all. If the court is inclined to do this, Judge, I can fashion an order and have it e-filed quickly. I think a B page might suffice. The warden just needs to be emailed, which Ms. Martinez has her email address, anything from the court indicating no contact.
All right. I will lift the no contact order. Just send me the order, defense, and we can go off the record. Ms. Martinez, your attorney, your husband's attorney, has stated that you all are trying for children. I always tell people it's great to bring new life into the world, but before you bring new life in the world, you need to make sure that your world is appropriate for a child.
Yes, ma'am.
So that means that your husband needs to be on his medications. He needs to be seeing a psychiatrist. So there are no harmful issues for the child. Do you understand?
Yes, ma'am, I do.
Because I want you to think about what would have happened if you had a child and all of this happened while that child was there or in that child's presence. It would not have been good.
Yes, ma'am, I understand.
All right, good luck to you.
Thank you so much. I appreciate you.
All right, you're welcome.
Thank you,
Mr. Toshi, unless you have someone else with us, you're excused. And could I have the attorneys on Vincent Garza, please?
Judge, that's me.
Alexandra.
I can be excused.
Yes.
Thank you so much. I appreciate it.
All right, you're welcome.
Alexandra,
have a good day, ma'am.
About county, yeah, I responded.
Oh.
Marcus, can I talk to you one more time in breakout room 6?
All right, the court is calling 2018 CR 4168W, State of Texas versus Vincent Lee Garza. Could I have parties announced for the record for the state?
Alexandra Williamson.
For the defense?
Robert Maurer for defendant, Your Honor.
All right, and are you Mr. Vincent Garza? Could you unmute for me, please?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state or the defense?
No, Your Honor.
No, Your Honor.
Mr. Garza, did you sign a document entitled Defendant's Consent to Appear by Video? Did you review it with your attorney and did you understand it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney, and did you understand them?
Yes, ma'am.
Are you the same Vincent Lee Garza who was placed on deferred adjudication in 2018 CR 4168W for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on April 25th, 2018 for a period of 2 years? Is that you?
Yes, ma'am.
And extended for a total of 1 year. Is that you?
Yes, ma'am.
State?
The defendant violated condition number 5 in Bexar County, Texas. The defendant, Vincent Lee Garza, did then and there fail to report to the supervision officer as directed in person or through virtual means, i.e. Zoom, for the months of June and August 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True.
The state will waive all remaining allegations.
Any objections to the state's waivers?
No, Your Honor.
Mr. Garza, did you understand by pleading true to violation of condition number 5, the court would find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Is there an agreement?
There is, Your Honor. We're asking for you to grant the state's motion, revoke his probation, and sentence him to 180 days.
I'm sorry, counsel, I didn't hear that. You kind of went out. 180 days?
Yes, under 1244.
Is that the agreement,
Judge,
defense?
It is, Judge. I just want to have a chance to speak to credit for some programs whenever the court's ready.
All right. Mr. Garza, could you unmute?
Yes, ma'am.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
Did you pay your restitution of $57 to the city of San Antonio for drug testing?
Yes, ma'am.
All right, the court will follow your agreement, grant the motion, find you guilty, not grant you community supervision, sentence you to 180 days in the Bexar County Jail under 12.44, give you credit for any time served. Is there anything else with regards to sentencing from the state or the defense?
Judge, yours from the defense. My client successfully completed the SATF program, and he had his problems with probation after he finished that. So we would ask the court to give him credit for the time that he spent in SATF.
All right, then the court will give you credit for any time served and credit for any successful inpatient treatment. Is there anything else from either side with regards to sentencing?
I didn't know, Your Honor. Judge, does the court have authority to pronounce it judgment satisfied, or I guess is that a jail?
Would the judgment be satisfied?
Yes, ma'am. He's got, I think, 62 days now jail time plus the SATF time.
All right, the court will show that the judgment is satisfied. It's satisfied, state?
Yes.
Okay. Mr. Garza, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Yes, ma'am.
Did you sign it and did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Garza, I'm going to tell you what I tell everybody else, and I tell people this because maybe no one has ever told them before. You can make a decision on whether or not you want to spend the rest of your life in or out of prison. That's up to you. If you have a drug or alcohol problem, there are plenty of free programs available in San Antonio. Do you understand?
Yes, ma'am, I do.
All right, good luck to you.
Thank you.
All right, Mr. Maurer, tell Rachel congratulations.
I'm very excited.
Yes. Hey, you're almost one step from freedom, but I will tell you, my mom said, children, you're never free. They always come back home.
Judge, she wants to go to med school. I will never be free.
You will not be free. Hey, but you know what? You know, and the bad part about it is once she becomes a doctor, she won't be allowed to treat you. So you still will be out of money.
I'm just wondering if I'll get any money back from her. I'm not going to hold my breath.
No, don't do that.
I'll tell her you said congratulations. Thank you, Judge.
All right. Thank you. Have a good one.
Okay, bye-bye.
Bye-bye. All right.
Judge Boyd, it's
Anyone
Michael
else back
Goins.
from the breakout rooms? Yes, Mr. Goins.
Yeah, I just got the Zoom link from TC4. May I go over to that court?
Yes, please. And just come back when you're completed it.
I will. Do I need to bring Mr. Torres back also when I come back?
No, if the state's agreement is that this case will be dismissed, he won't need to come back.
Thank you, Judge.
You're welcome. All right. Anyone else back from the breakout room? Eduardo Jimenez, what is happening with Mr. Crew?
Don't know whether he's available yet or not. I haven't heard from Norma.
All right, we'll see. We'll make sure we get him in.
Thank you, Judge.
Anyone else back from the breakout room?
Yes, Judge. Jesse Sanchez. I'm just waiting for the paperwork on MTR.
All right. Did you let Ms. Ferguson know that you needed that?
Yes, I did. And I already sent her Mr. Ayala's email.
Okay, awesome.
It's been sent.
All right, I'm going to put you and your client in a breakout room.
Judge, in this case, both options require him to be in the courtroom.
All right, Mr. Ayala, then we're going to recall this for this afternoon. Jesse Sanchez, you can still have your client fill out the paperwork in breakout room number 5. And then Mr. Ayala, we're going to recall you at 2. And so you'll need to be in the 187 District Court. It is 300 De La Rosa on the 4th floor. Do you understand?
Yes, ma'am. You want me to appear in person?
Yes.
Okay. Yeah, there shouldn't be a problem. I just have to get out of work.
All right, we'll see you at 2 o'clock.
Yes, ma'am.
Hey, thank you, Judge. I'll be back at 2.
All right, let me ask you this. It appears that your client doesn't know that he needs to be in court. Has everything been discussed with him?
Yes, I've discussed everything with him. Actually, he told me this morning he's in Kendall County on another MTR. So
not an MTR.
It's at about 11 o'clock. He should be able to get back by 2. And I'll call him and explain everything else again to him, Judge. He's got the 2 options. And if he
All right.
changes his mind, I'll let Norma know.
All right, thank you.
Okay, thank you, Judge. May be excused.
Yes, we'll see you back, Mr. Ayala, at 2.
Yes, ma'am.
All right, and you're excused. Dan Rodriguez, you're here?
I have Mr. Danny Acosta. I've already conferred with Tom on this case. There's an offer. It's just, I guess, to communicate the offer to my client.
Okay, is Mr. Acosta in custody or is he on bond?
He's in custody, Your Honor. He wasn't.
All
He
right,
wasn't
we'll
on
make
screen
sure.
yesterday.
All right, we'll make sure we get him on screen. Joe Bohack?
I'm here, Judge. We've got an agreement, I believe, on the MTR on Goggins, Raisha Goggins. I was just trying to send Alexandra a note to make sure we covered all our loose ends with some misdemeanor that's hanging.
Okay, great. And if you will just put that in the chat box to Ms. Ferguson so she can get those documents.
Already done, Judge.
Thank you. Anyone else back from the breakout room? Rafael Leal.
Rafael Leal, George. And I discussed the case with the prosecutor, and there is a discovery issue, and he's going to look into the file and get back with me concerning that, Judge.
What is the discovery issue? Because we're here for a discovery.
Right. It is there is an audio tape. This is sexual assault of a child, Judge. There is a mention in a police report that there is an audio tape, and I haven't been given a copy of it or an opportunity to review it. So he's
So
gonna look into it.
how long is it gonna take to get an audio tape to Mr. Liao?
As soon as we can find the file. There's a mention of it in what was submitted by the detective, but there's no mention about who was talked to. So I don't know if there actually is one or not. But if there is, we can upload it once we find the file.
Mr. Liao,
Yes, ma'am.
I'm gonna give you a 30-day reset. That's the last discovery reset I'm going to give. I'm not gonna give another one. This is an old case. It's from 2020. We're in 2021. And I see where we were last here. We were here on March 26th. It was recalled for April 7th. Then we were here on April 7th, and it was recalled for today. And it was supposed to be for CPS discovery. So do you have CPS?
No, I don't have
Discovery.
one. We're in the process of subpoenaing those records, Judge.
All right, see, everybody needs to stop being in the process and just do it, because I'm not giving another reset for discovery compliance because somebody's not subpoenaing what they're supposed to subpoena when they say this is what they want. So this 30-day reset will be the last date for discovery, Mr. Liao. Ms. Ferguson?
That should be a defense subpoena, Judge, because the state has CPS records in the file.
Oh, no, that's what I said.
Oh, okay.
Can the state provide me with those records? Since they already have them.
Ms. Ferguson, can I have a month reset, please?
Yes, ma'am. They can come back on June 2nd.
All right, we'll see you on June 2nd. Mr. Liao.
Not a 30 days reset, Judge.
I'm sorry, what?
That's not a 30-day reset.
All right. This is what I'm going to do then. Norma.
Yes, ma'am.
Can you recall them on June 7th?
Sure.
All right, June 7th, there's your 30-day reset. We will not handle any more discovery issues. So if there's nothing else, you're excused.
Well,
I'm not gonna be back here again. I'm not coming back here. We're not coming back here again for CPS records when everyone should do what they need to do in order to obtain CPS records.
Judge,
we're not going to come back again for a video when everyone can do what they need to do to obtain a video. This is an old case. There are not going to be old cases in the 187 District Court, and there have not been old cases in the 187 District Court that have not been taken care of.
Judge, I'm only one side of the equation, but I'll do the best I can. Since in order to expedite matters, since the state already has the CPS records made,
I'm sure it's a matter of picking up the phone, calling the state and saying, hey, can I come and schedule an appointment to look at your file and look at CPS records? I really think it's that simple. If it's not that simple, somebody tell me why it's not that simple.
Judge,
I think all you have to do is schedule an appointment with them.
I can break to schedule it right now. Are they present? I can go back to the breakout room.
All right, or you can pick up the phone and call them. I think they're okay. They will receive phone calls, but I'll send you to a breakout room. A prosecutor will meet you there.
Yes, ma'am.
And if you'll go back to breakout room number 7, and I'm sure they will make a schedule with you.
Yes, ma'am. Thank you.
Mm-hmm. All right, and we're just waiting for Mr. Crew to take his seat for the person who's waiting on Mr. Crew.
That's me, Judge. Thanks, Eduardo.
Thank you. Anyone else back from the breakout room? All right, everyone, just give us a moment then. As soon as someone's ready, I will take it up. And Rebecca, I see that you sent me some emails, so I'll review those.
Judge, do you have the paperwork on Goggins yet?
I will check to see. Just give me a moment.
Thank you.
Alexandra, the court does not have any paperwork on Goggins yet. Ms. Goggins, have you signed any paperwork? Could you unmute for me, please?
Yes, Your Honor.
Yes,
Judge,
have
she
you,
hasn't signed it yet.
I'm sorry, Mr. Bohack?
He has not signed yet. I thought there was some other issue to be dealt with in person with my client. I guess I was mistaken. We need to send her back to a breakout and get that paperwork signed for you.
All right, Ms. Goggins, if you'll go to breakout room number 8, please.
Yes, ma'am.
But I have signed some paperwork on Gutron.
Your Honor, I'm sorry, this is Eddie Brobenick. Is this an okay time to jump in for a second?
Yes, it is, Mr. Robinette.
Thanks, Judge. Judge, I talked with my client and I want to confirm the plea deal that I had with the prosecutor. Of course, because my brain is no longer working how it used to in my 30s. I can't even remember which prosecutor I talked to.
Okay, I cannot believe you're saying in your 30s.
Well, I'm getting pretty close to my 50s and I'm wondering if I'm totally losing it. Of course, Mr. Tochi would argue I never had it, which is a separate.
Mr. Brobnick, I'm already in my 50s. Don't say.
But
you're
first
in
of
your
all,
30s.
you look younger. Second of all, your brain was always higher functioning than mine. So.
Okay.
But I really can't remember who I talked with. I think he has a family case in a criminal trial. And I think that maybe David Martin was the family, but he agreed that the criminal trial could do whatever they wanted. I vaguely remember it was Alexandra, but I could be incorrect. I remember the plea deal. I just can't remember who I talked with.
Okay. See, your brain is working great. It was Alexandra.
Excellent. Could I just go to a breakout room with her, confirm the plea deal, and then assuming it's correct, we would be ready when the court was?
Yes, I've sent you to breakout room number 9.
Thanks, Judge.
Thank you. You're welcome. Nathaniel Navy?
Yes, can you send my client to breakout room 4 with me, please?
Yes. Oh, let me see. I don't see your client on the screen. Is there a Kirk Kinnear here? All right.
I'll go let him know. I had sent his client to the room earlier, but he never went. I see his name, but his camera's off right now.
All right, let me, you know what? I'm going to move him to 3, so maybe it'll pop up in the defendant's box. So we'll see if he goes. All right, and everyone, I'm going to take a 5-minute break. Just give me a moment, please.
Eduardo, can you go to breakout room 11, please?
Yes, okay, thank you.
Norma, this is Eddie Bravanek. My guy's going to plead on the MTR. They're going to tank the new cases. Paul Torres, is there a way you could send me, I put my email address there, the waiver of appeal and the other stuff on the MTR?
Yes, sir. I will do it right now.
Excellent. And then I'll probably need, I don't know if he's still in the breakout room, but I'll probably need to walk him through what he's signing. So probably have to go to a breakout room with him.
Okay, thank you.
Thank you.
Marcus, can you send him to the breakout room, please?
Yes. Eddie, who's your client?
Sorry, I muted myself. Paul Torres.
Okay.
He's in custody, Marcus.
Eddie, I sent you both to 12. He's in there now.
I'm grateful. Thank you.
Yeah. All right, guys, we're here on Gutron. Are the parties ready? Who is the state's attorney?
It's David, Judge.
Okay. All right, Mr. Gutron, if you could unmute for me, please. Court is calling 2020 CR 3666, State of Texas versus Jesus Gitron. Could I have the parties announced for the record, please, for the state?
David Martin.
For the defense?
Martin Guerra.
And are you Mr. Gutron?
Oh, yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No objections.
Mr. Gutron, did you review a document with your attorney entitled Defendant's Consent to Plea by Video Conferencing? Did you understand it and did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Gutron, did you sign a document entitled Application for Deferred Adjudication? Did you review that with your attorney and did you understand it?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gutron, did you review a document entitled True Bill of Indictment with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are proceeding on the lesser included offense.
I can't
Oh,
hear
I'm
you,
sorry,
counsel.
we've lost you.
Lost me. What?
Yes.
We're going to proceed on the lesser included offense of indecency with a child.
All right. So for the record, it appears that the state is proceeding on the lesser included offense of indecency with a child exposure. Is that correct, state? You're muted. We can't hear you.
Maybe if you get closer to your device, counsel, maybe?
I believe,
Better.
you know, this Friday is becoming snake bit, but at least we're all still
That work?
here.
Does that work?
Yes, that works.
I don't know what happened. Is that good?
So state, it appears you're proceeding on the lesser included offense of indecency with a child exposure. Is that correct?
Yes, that's correct.
All right, Mr. Gutron, did you review a document entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
The state is proceeding on the lesser included offense. And I'm sorry, state, there are 2 counts in the indictment. Are you waiving a count?
Yes, just on count 1 and we'll waive count 2.
Okay. Any objections to the waiver of count 2?
No objections, Your
Honor. Mr. Gutron, the state is proceeding on count 1, the lesser included offense of indecency with a child exposure. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gutron, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of indecency with the child exposure, count 1. State recommends deferred adjudication. State will take in consideration the following cause numbers: 2020 CR 3641, County Court cause numbers 616057, 654405, 654406, Night Mag number 600163, Chapter 62 compliance, and no contact with Karina Munoz. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor, although I believe there is one county court case which was not listed in the cases being taken into consideration.
And what would be that cause number?
616055.
State, is that correct?
I don't have a 616055.
Your Honor, I'm looking at the online information for the county clerk and district clerk court record search.
Yes.
So that's where I have that case number.
And what is the offense?
It's harboring runaway child.
That's
Uh,
the
sta-
057.
Excuse me?
616057.
I show that there are actually two cases for harboring a runaway child with two separate offense dates. And
All
that
right.
one is,
State, could you search and see if there's any cause number for county court cause number for 616055?
Judge, when you have a free moment, it's Eduardo here.
Yes, we're off the record. Yes.
Okay, so I've conferred with the state and spoken to Janelius. We're requesting a 30-day reset. I don't know if you know anything about this case, but there's it's like probably more than a dozen cases all combined into one arising out of the same incident or an occurrence. So there's just a lot, and I'm new on the case. There was a previous attorney, Rolando Garcia.
All right, just give me one moment, Mr. Jimenez.
Yes, ma'am.
Thank you. All right, State, did you find anything?
David, I think I know what it is. I was looking at the Jesus Edward Guitron Jr. So again, it's this part typical for this Friday, I suppose.
Yeah,
Oh, no,
there is a Jesus Guitron with that case number, but it's a different city.
Yes.
All right. Well, that's okay. But Martin, that shows that everybody is on their toes. You know, it may be the wrong toes, but we're on our toes. So, all right, Mr. Guerra, did you understand that to be the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
All right, Mr. Guitron, did you review a paragraph entitled Waiver of Appeal? Did you sign it in both places? Did you understand it when your attorney explained it to you?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
No, Your Honor.
All right, outside the plea bargain agreement, the state is asking for a TAP evaluation. There's no recommendation for the length of deferred adjudication. Is there an agreement or a recommendation from the state or defense with regards to length of deferred adjudication? Because it's not below the line.
We were going to leave the length up to the court.
All right. Then, Mr. Guitron, did you understand that the recommendation from TAP evaluation is a recommendation and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the lesser included offense in count one of indecency with a child exposure, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
Offer states one with the attachment.
Any objections?
No objections, Your Honor.
Mr. Guitron, did you review a document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, ma'am. Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Do you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after viewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding you guilty as you applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Before we do, Judge, this is the paperwork we did a few days ago.
Yes.
I wanna say, and I can't pull it up. Adobe's not letting me do it right now. The paperwork is named. His name is Edward Guitron. It should be Jesus Guitron.
Right. Let me.
On the style.
That is correct.
Yeah.
All right, and for the record, on all of the trial court certification, the indictment, the discovery acknowledgement, and the application, the defendant's name is listed correctly, and it's listed as Jesus Guitron. Is that your client's name?
Yes, Your Honor.
All right, are we proceeding with sentencing?
Yes, Your Honor.
Is there anything you wish to say on behalf of your client?
Yes, Your Honor, if I may.
Yes.
Your Honor, and again, just to clarify, his middle name is Edward. He does go by Edward. That's what everybody calls him. So I'll refer to him as Edward. But let me just say that Edward is 20 years old. He still has a long future in front of him. And when he was originally charged with the second-degree felony, this situation really forced him to mature and grow up quickly. He accepts responsibility. I think when all this happened, he was in a position where he was, when he met this young woman, he was in high school, she was in high school. And I think it bears noting that the age difference is 3 years, 5 months, and 3 days. So basically it was those 5 months and 3 days, which basically separated this case from an instance where he is charged with a second-degree felony to not have any charges at all. But as I said, he does recognize the severity of this. He does not have any more contact with this young woman. He wishes to comply with all the conditions. Respectfully, Your Honor, we're asking for a 2-year deferred adjudication. I'm asking for that because, again, I hope the court would take note of the age difference, the fact they're both in high school. I'll also ask court to take note of the fact that this is a recommendation of deferred, and there is no recommendation to the court for the length or the period or the term of this deferred adjudication, which I think is a cue to the court that they recognize the age difference as well. He has graduated from high school. He is working full-time right now, but I think he's in the long run going to be a good candidate for an early termination of this case, regardless of the term. I also think he's going to be a candidate to try and petition the court to relieve him of the requirement to continue to comply with the Chapter 62 requirements for that full 10-year period. But with that in mind, Your Honor, I would respectfully ask you to impose a period of deferred for 2 years.
All right. Mr. Guitron, if you're drug tested today, what are the results going to be?
I'll probably show the drug test, ma'am.
All right, and what will you be positive for?
Just marijuana, ma'am.
All right, you need to stop using marijuana. Do you understand?
Yes, ma'am.
All right, let me see defense and state in a breakout room very quickly. Let me see, my vision is not as great as it is. Let me see, Martin, what breakout room were you in? Number 1. Martin,
Yes.
if you go to number 1, please. And David, if you could meet us in 1. And everyone, just give us a moment. I'll be right back.
Norma, this is Eddie Brabenek. My client got both documents, but I didn't get the waiver of appeal. Would you be kind enough to resend that to me, ma'am?
Yes, Eddie, it was supposed to be attached to it. Let me see what happened. Give me one second. Eddie, it was in one email. You didn't get it?
Norma, this is Eddie Bravanek. I'm sorry, I was on with other court I was dealing with. I do see that my document says it's signed. Have you got everything you need from me?
Yes, sir.
Okay.
We
thanks.
got it. Thank you.
Hey, Norma.
All right, everyone, use your, we're back on the record, so everyone needs to use the chat box. So we're back on the record in 2020 CR 3666. The court has reviewed case law. The court will place the defendant on 5 years deferred adjudication based upon the case law and based upon the law. Mr. Gutron, if I could, based upon reading everything, I would place you on deferred adjudication for 2 years, but I cannot. So you'll be on deferred adjudication for a total of 5 years. The court will take in consideration 2020 CR 3641, County Court Cause number 616057, 654405, 654406, Night Mag number 600163, Chapter 62 compliance, no contact with Karina Munoz, regular UAs or the patch. You can do the patch if that will make it easier for you for time wise, but we're not going to be able to patch you until you submit a clean UA. There's to be regular Zoom reporting, proof of employment within 15 days. Is there anything else from either side with regards to sentencing? Anyone? Mr. Guerra?
No, Your Honor.
Mr. Gutron, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, with that, we'll close the record. I'm going to send you to breakout room number 1. Your attorney will meet you there, and probation will meet you there to go over conditions.
Thank you, ma'am.
You're
Thank
welcome.
you,
So if you'll go back to breakout room number 1, please. All
And
right.
Judge, just to let you know that I'll be going to breakout room 1, but Bianca Gonzalez Cielo is on to help me out today.
All right, thank you. And the court has just received some paperwork on Ms. Goggins and also on Mr. Torres.
Judge, can you put Joe Ray in a breakout room with Daniel De La Garza, please?
All right, just give me one moment.
And Judge, this is Eddie Bravanek, President, Mr. Torres, and whenever the court is ready, we're ready. I'm not trying to jump the line, just letting you know.
No problem. I'm signing those documents.
And Judge, is inmate Bella done already so I can send him back?
Who's his attorney?
Oh, the one,
If his attorney is Raphael Leal, then he is done.
yeah.
And Mr. Goggins, you've completed your plea? I'm sorry, Mr. Goins?
I have, Your Honor, and the case is TIC'd out of your court.
All right, thank you. Then you and your client are excused.
Thank you, Your Honor. Have a good day.
Thank you. Eduardo Jimenez on Janelius Crew.
Judge, may I request a reset of 30 days, please? I can give you further explanation as to why the time is needed if you need that.
All right, so why are we getting a 30-day reset?
Yes.
Go ahead.
Janelius it all arises out of the same transaction occurrence, but there are literally like about a dozen cases that I have to look at and all that discovery. And I used to be Rolando Garcia on the case. This is I'm new on the case, newly retained. I'm sure the DA can add his part. Thomas Nisbet was the DA on this.
All right, Norma, on Mr. Crew, can you give him a 30-day reset, please?
Yes, I'll give him, I guess, according to Rafael, the 30 days is June 7th.
All right. All right, we'll be back on June 7th. But Mr. Jimenez, have you received all the discovery?
And no, there's still some documents I'm waiting on, Your Honor. It's really, there's gonna be a lot of discovery here.
All right. Then you and your client are excused. We'll see you back on June 7th.
Thank you, Judge, I appreciate it.
All right, you're welcome. And Norma, can you let them know Mr. Crew can go back?
Yes.
And everyone, just give me a moment. All right, and John Winter?
Yes, Judge.
Yes, who are you here for?
Jesus Gonzalez Moreno. I was conferring with Tom Nisbet yesterday.
Yes. Okay. I'll send you to breakout room number 2.
Thank you, Judge.
Daniel De La Garza, I'm going to send you to breakout room number 3.
Thank you, Your Honor.
All right, and everyone else, I'm just waiting for the clerks to give me the paperwork, and then we will start on your case. All right, Mr. Rodriguez, Ross Rodriguez, who do you have?
Hey, Judge, how you doing?
Hi, great.
Oh, you're on the bench, Judge.
Well, yeah, you know, the computers are not working. So we got a late start today and they're still not working. So it's very dicey today. So who do you have?
Judge, I have Mr. Oh gosh, Jose Perez, I believe.
Let me look on this. Let's see.
It was a recall from Wednesday, I believe, Judge.
Yes, it's a motion to revoke and it's Jose Perez.
Jose
But yeah, I'm used to Zooming for my office. So it's hard to Zoom in here because then the deputies can't have theirs on because I get a lot of feedback. I'm going to send you to breakout room number 4.
Thank you, Judge.
You're welcome.
Your Honor, could you please put Gonzalez, he's in custody, Gonzalez in breakout room 2 with his lawyer, please?
All right, Mr. Gonzalez, if you'll go to number 2. And then I have the paperwork on Goggins. Who's the prosecutor on Goggins? And Mr. Brobnick, you'll be next. I have the paper work on that.
Thanks.
Alexandra Williamson was the prosecutor on Raisha Goggins, Judge.
All right, thank you. And everyone, I appreciate your patience today. Okay. All right, court is calling 2019 CR 9099, State of Texas versus Raisha Goggins. Can I have parties announced for the record, please, for the state?
Alexandra Williamson.
For the defense?
Joe Black for the defense.
All right, and are you Miss Goggins?
Yes, ma'am.
How do you pronounce your first name?
Raisha.
Raisha, okay. We're proceeding by video because of the pandemic. Any objections from the state or the defense?
No, Your Honor.
No objection.
Ms. Goggins, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. If you review that document with your attorney, did you understand it?
Yes, ma'am.
Are you the same Raisha Goggins who was placed on community supervision in 2019 CR 9099 for the offense of assault family second on November 21st, 2019 for a term of 4 years? Is that you?
Yes, ma'am.
I'm gonna need you to speak up.
Yes,
State.
ma'am.
Reading from the first amended motion to revoke probation, the defendant violated condition number 1 or about the 26th day of February 2021 in Bexar County, Texas. The defendant, Raisha Goggins, committed the offense of failure to identify in violation of condition number 1.
Are you pleased with that? True or not true?
True.
The state will waive all remaining allegations.
No objections.
Any objections? Ms. Goggins, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you to 4 years in the prison and $1,000 fine? Did you understand?
Yes, ma'am.
I need you to speak up.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor. We're asking for you to grant the state's motion, revoke Ms. Goggins' probation, and sentence her to 90 days in the Bexar County under 1244. So take into consideration.
Sorry, I didn't hear you, counsel. Just a minute. After Bexar County Jail under 1244.
The state will also take into consideration 2 cases. County Court case number 656271, Nightmag 587541.
All right, is that the agreement, defense?
Yes, Judge, I was just checking the case numbers. That looks like exactly what we've agreed to.
All right, Ms. Goggins, is that the agreement?
Yes, for time served.
Are you requesting that the court follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
I didn't hear you, ma'am.
Are
Yes,
you waiving
ma'am.
your right to appeal?
Yes, ma'am.
All right, is it the intent that this judgment is satisfied or no?
Yes,
Yes.
Judge, I believe, speaking with my client, she advises me that she's had in excess of 90 days in the jail since the initiation of this case. I think that I requested, but I didn't get yet from the clerk confirmation on the number of days, but I know they're very busy.
All right, State, is this a judgment satisfied?
Yes, Your Honor.
And I know it's Friday, Judge, and I know things are crazy. I'm just hoping that directive can be made it to the jail before 5 p.m. today.
Oh, Mr. Boeck, this is the 187 District Court. We have a fabulous staff. They'll make sure that it's in there.
I
We're
know, it
working
goes without
towards-
saying, Judge. I just felt obligated on behalf of my client because she had a little bit of a glitch last time and she did a little few extra days.
Okay. All right, and whoever has the alarm going off their phone, if they'll silence that, please. All right, the court will follow the agreement. The court will grant the motion, sentence you to 90 days in the Bexar County Jail under 12.44 of the Penal Code. Take in consideration County Court Cause number 656-271, NIGHTMAG number 587541. And as previously stated, the court found violation of condition number 1 true. Court will show the judgment is satisfied and there's an affirmative finding of family violence. Ms. Goggins, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you
Yes.
electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also, because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
Ms. Goggins, we'll go off the record. The only advice I can give you is you need to know better and do better. How old are you?
33, ma'am.
All right. Do you want to be 33 years old going in and out the prison? Because this easily could have been a 4-year prison sentence. Do you understand?
Yes, ma'am.
All right, Norma, can you let them know that Ms. Goggins can go back? And Mr. Boheck, thank you for your patience.
What seat is she in, Judge?
She is in L21.
L21, thank you.
Yes. And the next person up is on, yes, Ms. Goggins?
So does that mean I'm not on probation anymore?
No, you're no longer on probation.
Okay, thank you so much, Judge.
You're welcome.
Can I be excused, Judge?
Yes.
Thank you. Have a good weekend.
Thank you, you too.
Finals are coming up.
Go back now.
All right, who is the person who is the prosecutor is on Mr. Torres? All right, Mr. Torres, can you unmute for me, please?
Yeah.
Hey, Judge, before you start that, Gonzalez, I see him just sitting there. I think he needs to go into 2, but he might need some help and or a translator. I'm not sure.
All right, just one moment. Yes, he does need a translator. Norma, is there any way you can instruct Mr. Gonzalez to go to breakout room number 2?
Yes, hold on for just a moment, Judge.
Thank you. And Mr. Bravanek, is Paul Torres the same as Paul Zachary Torres, or is that someone different?
Judge, I didn't ask him that question. Mr. Torres, can you answer that, please? I'm sorry.
Yes, ma'am, I am that person.
So you're Paul Zachary Torres as well?
Yes, ma'am.
All right, State, the agreement that you've reached with him on this case, is that going to take, is it going to address the other cases that he's charged with or no?
All of them, yes.
All right.
And Judge, before you start, can you put Acosta in with Dan Rodriguez in a breakout room?
Yes.
Thank you.
Dan Rodriguez, I'm going to send you to breakout room number 1.
Thank you.
Mr. Acosta, I'm sending you to 1. Court is calling 2015 CR 8757 State of Texas versus Paul Torres. Could I have parties announced for the record, please, for the state?
Alexandra Williamson.
For the defense?
Eddie Bravenick for Mr. Torres.
All right, and are you Mr. Torres?
Yes, ma'am, Your Honor.
We're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
None.
Mr. Torres, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Torres, did you review the following documents with your attorney?
Yes, ma'am.
The first one being first amended motion to enter adjudication of guilt and revoke community supervision. Second amended motion to enter adjudication of guilt and revoke community supervision. And motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am, Your Honor.
Are you the same Paul Torres who was placed on deferred adjudication in 2015 CR 8757 for the offense of theft $1,500 to $20,000 on January 4th, 2016 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Reading from the second amended motion to adjudicate probation. The defendant violated condition number 5. In Bexar County, Texas, the defendant, Paul Torres, did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, and November 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True.
The state will waive all remaining allegations.
Any objections to the state's waivers?
No, Your Honor.
Mr. Torres, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Did you understand?
Yes, ma'am, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am, Your Honor.
Court will find violation of condition number 5 true. Is there an agreement?
There's a partial agreement, Judge. We are both in agreement, and we're asking for you to grant our motion, adjudicate him guilty, revoke probation. We are not in agreement to the term. The state is asking for 2 years, and we do have a number of cases that were TIC. I can speak on that at the time.
All right, and what cases are you taking in consideration?
Court case numbers 609490 and 615861. There are 3 case numbers. 2019.
I'm sorry, counsel, I didn't hear you. There are 3
district court case numbers. 2019 CR 9516. 2021 0382.
I'm sorry, was that 0382?
Yes. 2021 CR 2276 and 2 JN cases 1962021 and 1962239.
All right. The court then, Mr. Torres, the court is finding violation of condition number 5 true, and the court will grant the motion. The court will find you guilty. The court will not grant you community supervision. The court will take in consideration 609-490, 615-861, 2019 CR 9516, 2021 CR 0387, 2021 CR 2276, JN numbers 1962021, 1962239. And the court will hear argument with regards to the sentence. State you're asking for 2 years.
Yes, Your Honor. And I just wanted to highlight the district court numbers.
I'm sorry, Counsel, could you please repeat what you just said? There was an interruption in the video feed.
I would like to clarify the district court number. It should be 2021 CR 0382.
Okay, thank you.
And yes, Your Honor, obviously this is a state jail felony. The state is taking into consideration quite a few cases, but regardless of that, this defendant was not successful on probation. Obviously, he didn't report for almost the entire year in 2020. There was quite a few other violations, so we believe that 2 years would be appropriate in this case.
All right, defense.
So Judge, you and I have both done this a while, and when I looked at the cases, I mean, the cases were not good from the evidentiary standpoint, which is, I think, why they were taken into consideration. That having been said, that they showed me some underlying problem. And the reason I say that is that, I mean, you've done this a long time, you've seen it. I know that you know there was some underlying problem. So I addressed that issue with Mr. Torres, and I asked him, what is your underlying problem here? You know, are you hanging around the wrong people? What's the situation? And what Mr. Torres essentially told me is that there were two things. Number one, he was using synthetic marijuana. And number two, he was hanging around the wrong people. And I'm telling you that straightly because, I mean, there's some problem, right? There's something that has to be addressed by this sentence. So I then said, you know, this is obviously a problem. And even if you aren't being sent to prison on these other cases, you know, the judge is going to have to address this. So I asked him what happens when you get out? Why should the judge give you less time rather than more? And essentially, he has a plan. He does have family here. He has a sister that's a good support network for him and a stepfather, folks that he had not taken advantage of. Before the new cases came down, he started a relationship. He has a partner that he will be living with if and when he is released. Well, I guess the when is really the truth. And that person is a good support network for him. He also has a job lined up. Essentially, his plan is do what the rest of us do, which is work and spend time around your family. I think that's likely to be a successful plan. So I think the real question is, I understand that some time in jail or prison is and was necessary in order, it's like touching a hot stove. He obviously was not getting the message by talking to him, and he needed to burn his hand on that hot stove. The real question is how much more time is necessary? In my opinion, given his acceptance of the reasons behind it, I'm comfortable asking for the court for somewhere around a year. And I know that you give out more sentences than that on a regular basis. However, he is a young man, and that's a significant sentence to him. He already has approximately 6 months in. Whatever you do, we do ask that you give him credit for that time. And then he does understand and respect whatever sentence you give him, but that is my reasoning for why I think that is an appropriate sentence.
All right. Mr. Torres, can you unmute for me, please?
Yes, ma'am, Your Honor.
All right. Why should the court not give you 2 years?
As Mr. Brovnik said, I do have a great support system waiting on me. I'm ready just to be an average person and just go to work and do the right thing.
I'm sorry, sir. I can barely understand you. Just a little louder.
I am ready to go to work and just do the right thing. I do feel like this time here in jail has definitely taught me a lesson as far as taking my responsibilities and learning from my actions.
I mean, that's what everybody says when they get caught, right?
Yes, ma'am.
I mean, that support system that you're talking about, they were always there.
I didn't have such a great relationship. You know, it's always been me since I was about 17 years old. I reached back in, you know, made things right. And I got a lot more help than I did have prior to, you know, me getting in trouble and things like that. Like I said, just growing up and just taking responsibilities.
Why were you not reporting?
Well, I was under the influence of synthetic marijuana. And, I'm gonna be honest, I was kind of scared with anything at the time. So me being scared like that, it just didn't add up to, you know.
All right. This is what the court is going to do. The court is going to sentence you to 18 months in the state jail facility. Give you credit for any time served. Take in consideration the previous cause numbers that I've already stated. Is there anything else with regards to sentencing from either side?
No, Your Honor.
No, Your Honor.
All right. Mr. Torres, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney and did you understand it?
Yes, ma'am, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it is related to the allegations in the motion and not the fact that you're on deferred adjudication. Do you understand?
Yes, ma'am.
All right, Mr. Torres, I know 18 months may seem like the end of the world, but it's not. When you get out, you need to follow through on what you're doing. What I find is when people are in custody or in a situation that they don't want to be in, they have all these great dreams, they have all these plans, and then once they taste freedom, all those plans go out the window. So immediately when you're released from custody, what you need to do is you need to find the nearest AA, NA meeting. You say you're going to be with your family and they're going to keep you on the straight and narrow, then you need to hold on to that and do that, because otherwise you're going to find yourself in and out of prison. Do you understand?
Yes, ma'am.
All right. Also, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am, Your Honor.
All right, Mr. Torres, good luck to you. I hope everything turns out well for you.
Yes, ma'am.
All right, Norma, can you let them know that L1 can go back? And Mr. Bravanek, thank you for your patience. You're excused for the rest, a great rest of the Friday.
Thanks, Judge. And I guess I've been doing this too long because I accurately predicted what you would do. Not only the question you would ask, but the sentence you would give. So, I mean, that's good though. I mean, the most important thing is that we have a judge that is predictable, stable, and gives out fair sentences. So thank you for your time.
All right, you're welcome.
Take care.
All right, thank you. All right, is there anyone else who's ready?
Yes, Your Honor. Daniel De La Garza on the Jose Sanchez violation report.
Let me find the violation report. Just give me a moment.
Thank you, Your Honor.
Judge, in the meantime, may I make an announcement on Mr. Moreno Gonzalez?
Yes. And Norma, can I get the violation report on Jose Sanchez?
Yes, ma'am.
All right. And then let me find you on the docket, Mr. Winter, just a second.
Sure.
And Norma, if you can see if Judy Wimmert can come back on Renee Espinoza, please.
Judge, that one was reset. It was accidentally put on the docket, Judge.
All right. All right, John Winter on Mr. Jesus Abraham Gonzalez Marino. What are we doing?
Yes, Judge. So I've gotten an offer from the state. I've conferred with my client. We would like a little bit of time for him, since this is the first real offer we've gotten, a little bit of time for him to contact some family, mull it over, but it may resolve everything here. So if we could just get maybe a month to consider the offer.
All right, has all the discovery been received?
It has.
Yeah, Judge. And the prior offer was crummy. So we have made them a new offer. We're more fond of a week than a month. But court's discretion.
All right. So, John, what I'll do is I'll give your client, is your client on bond or in custody?
He's in custody, Judge.
All right. Let me see. I don't see him on the screen.
He may still be in the break. Oh, no, he's not in his chair. I don't know where he is, but it's 187 Gonzalez. That's him.
Okay. What I'll do is I'm going to give you a 2-week reset.
Okay.
If he needs to talk to whatever family he needs to talk to, then he can do that. Ms.
Sure.
Ferguson, can you bring back Jesus Gonzalez Marino in 2 weeks, please? And defense, this date will be your plea deadline date.
Okay, Judge.
I need a 2-week reset on Marino.
And John, when looking at the evidence on Corny
All right,
Pierce, it is 2 knives. There are 2 knives in evidence. I thought it was just one, but there's both in there.
And I'll have an announcement.
You only
Judge.
need one.
All right. John, on your client,
Yeah,
we're going to come back on May 21st.
May 21st. Okay, Judge. May we be excused.
Yes, you're excused.
All right. See y'all next week on Corny Pierce.
All right. See you then. Oh, and John, we'll
Yeah.
be giving you a call so that we can test all of the equipment in the courtroom.
For Pierce,
Yes.
isn't that the one we talk about? We'll have to actually be present in the courtroom, right?
Yes. And so, but we'll still need to test the equipment. You know that the court had water damage and we still don't have carpet down. So
Really?
no, we do not.
You know,
At first,
Judge, I have to say I have a certain, level of comfort. There's certain needs I have in order to have a trial. I have standards.
well, they thought and they suggested that they would just dry it. And I'm telling them you can't dry, the padding underneath. You'll probably still end up with mold or mildew. So
I think that might be an issue. Yeah.
that might be an issue. All right. And Norma, on his client, Mr. Gonzalez, if we can make sure that for him, we have an interpreter on the
Yes.
21st. All right. You are excused. Thank you.
Thank you, Judge. You all have a good weekend.
All right. You too. Thanks for your patience. All right. Jose Sanchez.
We're ready, Your Honor.
All right. Is your client in the courtroom? Where's your client?
Believe he's in the courtroom.
Your Honor, present.
All right. Who were you conferring with?
Mr. Joe Ray. I love
All right,
that name.
Mr. Joe Ray.
Rizzo.
No, I'm talking about the prosecutor, sir.
Oh, I'm sorry.
Just
But
one
we like your
second.
name too. We like Rizzo.
Okay. All right, awesome.
All right. And Maria, this is not on the record. Do you all have an agreement with regards to the violation report or an explanation for the violation report?
We have both, Your Honor, but we have an agreement.
Okay. All right, so we're not on the record. This is the second violation report you've had, Mr. Sanchez. So why do I keep getting violation reports from Mr. Sanchez?
Well, Your Honor, the first one seemed to be something that was worked out with another prosecutor in this in your court. But on this one, it's a thing where he was no longer employed at that apartment complex. So the violation, I think it's a misunderstanding in that regard. I think what he's telling me is that he went to go pick up a final check, and that was the extent of the violation, so to speak. So I've conferred with the prosecutor, Mr. Joe Ray. What we've agreed on is that we would put Mr. Sanchez on full GPS, so on full house arrest, with the ability to look for work. and then we'll revisit, whether we do partial or not once he gets a job. But Your Honor,
When
I think
you
it's
say
notable.
ability to look for work, because a lot of people are allowing you to look for work online.
So we talked about that. He's, that's primarily what we want him to do. If there's an interview or something he needs to go to, then the idea would be that he needs to contact pretrial and get permission.
All right, so this is what I'm going to do. I'm going to alter the main conditions to full GPS then. And I'm going to leave it at full GPS. Mr. De La Garza, if he has an in-person appointment, let the court know, and then I'll consider the in-person appointment.
Yes, Your Honor.
But for now, so there's no confusion with pretrial services, and it will be full GPS.
Okay.
And State, was that your agreement that you had reached?
It was, Judge, yes.
All right, Mr. Sanchez, you're going to be on full GPS. That means that you can't leave your house. And what I'm being told about GPS, you can't even really go in your backyard. So I know there are Memorial Days coming up. People usually don't celebrate Memorial Day and realize it for what it is, so they decide to barbecue. You had better let somebody know that you cannot work the grill. If somebody comes on the porch, wants you to bring the potato salad outside, you need to let them know you can't even take potato salad outside your house. You understand?
Yes, Your Honor.
All right, if there's nothing else, that will be all.
Thank you, Your Honor.
Thank you, Mr. De La Garza, for your patience. Mr. Sanchez,
I
thank you.
have it in my pocket at all times, Your Honor.
Oh, thank you. I appreciate that. Have a good one. Have a great Friday.
You too. Thank you.
Well.
Dan Rodriguez.
Yes, Your Honor. I've conferred with the state and with my client. There is an offer on the table. Just request a little bit of time, very short reset to consider the offer.
All right, Mr. Acosta,
He's in jail. He's
we're
on
going to
the
call
Zoom.
you back on May 21st. That will be your plea deadline date. There will be no further extensions of plea deadline dates. So whomever you need to talk to, you need to talk to them.
Okay, ma'am. Appreciate that, ma'am.
All right, Mr. Rodriguez, you and your client are excused. Thank you for your patience. Normie, can you let them know that 14K can come back?
Thank you, ma'am.
Thank you.
You're glowing too.
Oh, well, I guess it's the angel halo in me. I have no idea.
It's a Friday, that's why.
Yeah.
Sorry, Judge, what's the judge?
14K.
Thank you.
Thank you, Judge. You have a nice weekend.
Thank you, you too.
Are you giving him a 30-day reset, Judge?
No, he's coming back on May 21st.
May 21st, thank you.
Yes, thanks. All right, Ross Rodriguez.
Hi, Judge. Could I be put in a breakout room with my client, Mr. Pettis?
Okay, is your client in custody?
Judge, on Bettis, they have, Judge, can I get in a breakout room with you, Judge?
Yes. Norma, I'll meet you in breakout room number 1. All right, Mr. Rodriguez.
Yes,
It
Judge.
is a Friday. It's good that none of this happened on a Monday. With regards to your client, there's been some sort of issue at the jail. So we're gonna have to recall you back at 2.
I'm going to be in a Zoom hearing already, Judge, from 1 to 4 o'clock. It's a knockdown, drag out probate hearing.
All right, Norma, can we recall it for Monday, the 10th?
Yes, ma'am.
All right, then we'll see you back on May 10th.
Thank you, Judge.
All right, you're welcome.
Can I call you right back? Okay.
All right, Nathaniel Navy.
Yes, Your Honor.
Yes, what is happening with your client?
We're going to take a plea this morning, Your Honor. We've finished, I think, all the plea documents, except I had given them my client's old email address. So Norma, I just sent you a chat with the new email address. If you could resend the documents to that one.
Yes, sir. I'll do it right now.
Okay.
All right, and what I'll do is I'll check my email to sign our documents.
Okay. Thank you, Judge.
Judge, I just sent you a chat.
All right, thank you. Just give me one moment.
Okay, Nathaniel, they've been sent.
Okay, great. Thank you.
All right, Mr. Kinnear and defense, if you'll go to breakout room number 1 so the clerks can swear you in, please.
Okay, sorry, Judge, I was just on the phone with them. We just hung up. Did you say go to breakout room number 1?
Yes, please, just to be sworn in, just whenever you're ready.
Okay, my client needs to get in there?
Yes.
Okay. Kurt, can you go ahead and join breakout room 1? You just click the box that says join breakout room and then join breakout room number 1.
Yeah, I don't. Oh, breakout rooms. I see. Okay.
There you go.
Stop.
All right, Rebecca, I'm ready on Mr. Arturo. Mr. Arturo, if you could stand up for me, please. And to the court reporter, we're not on the record.
Okay, Judge.
Thank you. So, Mr. Arturo, I received a supplemental report on you. Are you aware what the issues are? Yes.
Presumably, which is why I thought it was a probation hearing meeting actually, because it came from the probation number.
Okay.
And then I'm coming from Seguin, so I didn't know.
No problem. I want you to be aware that if you do not do what's required there's going to be an issue. You understand?
Right. She emailed me. I was in custody when so I didn't get my probation papers. So she emailed them to me this week, and then she's going to email me the fifth class that I can take. The issue is because I'm in Seguin, they didn't know if I could take it in Seguin. So I guess they're waiting to get you, or I don't know what's with that. But she's emailing me where I can take it here in San Antonio. If I have to come into San Antonio, that's fine.
Okay, just one moment. To Rebecca, is Mr. Alanis able to transfer his probation to Seguin? Would you prefer it be transferred to Seguin? All right, how old are you? All right, and who's with you?
My mother.
All right, Mom, here it is. It's Mother's Day, and you're having to be here with a 41-year-old, your son, and he's looking at you as though you're his personal assistant. So here's the thing. I know you're the person who's on deferred adjudication, not your mom, right? And so she's going along with you on this ride because I guess she has to drive you everywhere. So you had better start making her life easier for her. You understand? It's Mother's Day. What are you bringing to the table? No, I mean, it's Mother's Day. You need to do something for your mom. All right, so this is what I want you to bring to the table for her. Stop bringing her worries. All right, one time my mom asked for peace and quiet, and my brothers were like, we can do many things for you, but the quiet part we can't give you. So I want you to give her peace and quiet. Do you understand? Rebecca, is he able to have his probation transferred to Seguin? Do they have the BIP class there?
They should have a BIP class. It's just a process. We just had to go through the probation department. So that way Seguin, we can verify if Seguin will accept them.
All right, so this is where we are right now then. Let's keep a weekly Zoom for him until we have the transfer to Seguin for the BIP, because otherwise his mom will have to drive him back and forth. Are there any, are they doing BIP by Zoom or are they doing it in person?
They stopped doing online because everything's resuming back to normal.
All right, so let's hold off on BIP for a little bit until we find out from Seguin if they will transfer him to Seguin and allow him to do BIP there, because I don't want his mom to have to drive back and forth with her 41-year-old son to get him to his BIP classes.
Yes, ma'am.
All right, because she doesn't need BIP. Oh, he's 47? Oh my gosh, you should have kept that quiet. He's 47 and his mom has to drive him back and forth for BIP classes. And based upon my conversation and interaction with her, she doesn't need BIP. So we're going to try to make it a little simpler for her. So you're going to need to stay in contact with probation. Are you able to Zoom? All right, so you're going to have to stay in contact with them weekly until you're transferred to Seguin and until you're in the BIP class, okay? I don't see you writing it down. You're going to depend on your mom to remember that? All right, can we get that so he can write that down? So, yes, you gotta, I'm gonna need you, Mom, I'm gonna need you all to remain in court just a little bit so he can go into a breakout room. We just can't do a breakout room right now because I'll get a lot of feedback. So just give us a moment and hopefully your Mother's Day gets better. Okay. Okay. All right.
Judge, I sent you a chat.
Okay. All right, yes, we can do that. Aw. Aw. All right, so we'll bring him back on Wednesday then, Norma.
Okay,
all right, and then Nathaniel, I'm just waiting for your client to be sworn in. Once I have that, we'll go from there.
Okay. And we're in breakout room 1. We're just waiting for somebody to meet us there.
All right, to the clerks, could you go to breakout room number 1, please, and swear in Mr. Kinnear?
Judge, do you want to let inmate Montoya? know?
Yes. Mr. Montoya, could you unmute for me, please? Mr. Montoya, your attorney is actually in a bench trial in another court, and he's going to be there for a while. So he's requesting that we recall you back on Wednesday. So we're going to recall you back on May 12th and take care of your case, okay?
Okay, miss. All right, thank you, Judge.
All right, thank you. Thank you for your patience. Have a good rest of your day.
Okay, man. You too.
All right, thank you.
Nice. Happy Mother's Day too.
Thank you.
All right.
Bye-bye. Norma, can you have 14F go back? I'm not a mother, but I do have students, so I consider them all my children. Yes. Okay. All right. Rebecca, I'm going to send you to breakout room number 2.
Okay.
And he will meet you there.
Okay, thank you.
Who's the prosecutor on Kinnear? Thanks, Marcus. I love that you're able to just pop in. Just give us a moment, everyone. All right, the court is going to call 2020 CR 2060 State of Texas versus Kurt Elliott Kinnear. Could I have parties announced for the record, please, for the state?
Marcus Sanders.
For the defense?
Nathaniel Navy.
And are you Mr. Kinnear?
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Kinnear, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all of the discovery in this case, and did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Kinnear, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge, we are.
Mr. Kinnear, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault, serious bodily injury? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, I do, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, I'm sorry, Mr. Kinnear, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, I do, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Kinnear, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, I did, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine. The state opposes your application for deferred adjudication. The state recommends community supervision. There's to be restitution to Jeffrey Schauberger, Schauberger, and no contact with Jeffrey Schauberger. Did you understand that to be the plea bargain agreement?
Yes, I do, Your Honor.
Defense is at the plea bargain agreement.
Yes, Your Honor.
State is at the plea bargain agreement.
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not, Judge.
Next, I'm showing you outside the plea bargaining agreement, the state is asking that your community supervision be for a term of 5 years, there be a TAP evaluation, 100 hours community service restitution, follow recommendations of TAP and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor, I do.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's no contest plea.
Yes, the state offers State's Exhibit 1 and its attachments.
Any objection?
No, Your Honor.
Mr. Kinnear, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt. Are we proceeding with sentencing? Is there a request for a PSI?
Judge, we're okay with waiving PSI if you're okay with that.
State? Because here's the thing, is there a reason why the state is not agreeing to defer? Is there something that I need to know more about the defendant's history?
Judge, I would ask for a PSI just so that the victim has an opportunity.
All right, so I'll order a TAP evaluation and we'll set it for a PSI date. Norma, when can we come back?
1 second, Judge, let me look. No. Are you gonna want him in person, Judge?
No, it doesn't have to be in person. It can be by Zoom.
Okay. He can come back on June 18th.
June 18th?
Yes, ma'am.
All right, Mr. Kinnear, what will end up happening now is I'm going to send you to a breakout room. Probation is going to give you instructions. I'll make a decision on your application on deferred adjudication based upon the report I received for probation and any other evidence that's presented to me.
Thank you, Your Honor.
You're welcome. I'll send you to a breakout room to speak with probation. Probation, if you'll go to breakout room number 2 and Mr. Kinnear.
It'll be Bianca Gonzalez.
All right, I'm sending you to number 2. And after that, you both are excused. Thank you for your patience.
Thank you, Judge. And actually, there was one more matter. I don't believe it's on your docket. but we had discussed it on Wednesday. It was for Tyrone Shepard. The state had filed a motion to amend his bond conditions to include full house arrest GPS and removal of firearms. The state conferred, and we would agree to have the removal of any firearms if there are any, but then to have the GPS be for tracking, to allow him to go to therapy and do whatever errands he needs to run because he does live by himself, Judge.
All right, who are you conferring with?
It was with Ms. Stewart and then also Mr. Nesbitt.
All right,
And I
I
believe
saw.
we're probably both here today.
All right, so Ms. Stewart or Mr. Nesbitt?
Judge, sorry, I'm on a work
No
call.
problem.
And Marisa, I think she said that she texted me here. She said, I saw Judge's message. I'll log back on at 2 p.m. I don't know what your message was.
Okay.
Oh, it said we're going to finish the plea and then break till 2 p.m.
Yes, that's what it says.
Okay. Can
But
we
if
come
you all
back at
have,
2?
if you guys have made an agreement with Mr. Navy,
Yeah. Can we just do it in writing by email?
yes, if you send me the agreement by email, Mr. Navy, I will sign it. That way you don't have to come back.
Okay, wonderful. Thank you.
Yes, ma'am.
All right, thank you.
Thank you.
Bye.
All right, everyone, we are going to stop live stream. And if we, let me see if we have any, yes, we do have several cases. So we'll be back at 2 p.m.